shout out to everybody. We back again. Shout out, man. Like, yo, we've been having some wild lives, you know what I'm saying? So shout out to everybody that's been tuning in. You know, thanks for the support. We got like, yo, I'm rocking with y'all, bro. You know what I mean? We got like almost 1,000 subscribers in like 2 days. You know, so I really appreciate that. You know what I'm saying? That's showing me that y'all rocking with the channel. You know what I'm saying? So I do want to say shout out to Law and Crime Network. They have, it looks like it's going to be the closing arguments. You know what I mean? For the, hold on, for the Dolph, you know, and, you know, the Justin, what's his name? Justin Johnson, you know, is the guy, you know what I mean? So shout out to everybody. We did do a live on Diddy and Eric Adams, which is the mayor of New York that is now going to be having an indictment, you know. So I don't know, like, as far as that guy, like, we'll end up seeing like the trial when that happened, you know, and stay in tune with that. But I do think, to be all the way real, you know, like a lot of that may end up having to do with Diddy, man. And we kind of broke a lot of that down, talked about it, you know what I'm saying? Shout out to the Art of Dialogue. They allowed me to use like some of the footage. We reviewed like Dr. Umar Johnson's like videos, and yo, that dude's like perception of what's going on in terms of what's happening with that Diddy trial is just insane, man. Like how he broke that down, it was lit, you know what I'm saying? So shout out to him. As far as this Justin Johnson versus Young Dolph, I do want to say, me personally, I think this guy's guilty. We sat through like all of the days like of the trial, you know, and we kind of like watched everything. So the opening statements from the prosecution and the defense attorney showed not much of what was going to happen like later on, right? In terms of the defense, the prosecution created a compelling argument early on in the you know, with the opening arguments, basically saying, yo, this is not 1981, this is not 1991. There are cameras everywhere, you know, everything that you do will be monitored, you know, and he can show that there's evidence sufficient enough to end up locking this dude away. You know, talking about him having the clothes on that was used during the you know, unfortunate event that happened, you know, in multiple different locations. And then throughout the trial, we ended up seeing the prosecutor was actually able to back up a lot of what he was claiming, you know, and, you know, he had a lot of witnesses that was brought to the stand. Mainly, you know, he had the TBI, which is the Tennessee Bureau of Investigations, and with the TBI, they, you know, they went over the cell phone towers, because a lot of times what defense attorneys like to do is say things like, you know, like, how many hours of experience do you have reviewing, you know, cell phone data, and how can you actually track and make sure that, you know, that the towers are pinging my, you know, defendant at this particular location at this particular time. And they try to mix that up, because sometimes with the cell phone towers, they, you know, it may be a bunch of them within the same area, so they, you know, not prosecutors, but defense attorneys think that they can kind of use that as an angle to say, well, you can't necessarily pinpoint where like my client was. But the TBI expert, you know, with his, I think he said he had 1,000 hours plus of experience, like understanding like the cell phone network and breaking all of that down. Like he kind of just like wiped the floor with, you know, anybody even thinking anything opposite, right? And then we seen Young Dolph's sister, she was on the stand. We seen Cornelius Smith, he was on the stand. I think that may have been day 2. He ended up just spilling the beans about everything that happened that night, you know, so much so, like, I'm very, very surprised that they actually allowed that, you know what I mean? So I you know, in terms of defense, just allow this guy just to talk and say so many things that, you know, like you would be thinking like, okay, well, this is hearsay, you know, this is an obvious objection. You know, we all watch court TV shows every once in a while, like we kind of know a little bit of what's going on. We're not lawyers, right? But there was so much hearsay that Cornelius Smith was able to say that went unobjected. I was just perplexed looking at this entire situation. It's kind of like the defense attorney sat back and allowed the prosecution to just run, you know, but with so much information, like video footage, it wasn't nothing that, you know, the defense could really do. You know what I mean? Like, just to keep it all the way real, Cornelius Smith laid out everything. He ended up outing Big Juke, you know, like, and letting everybody know there was $100,000 hit on Young Dolph from Big Juke. He talked about Govan, you know, his involvement in everything, and this case has been just spiraling, you know, away from the defense. You know what I mean? And the prosecution I think this was a landslide. I called it. I said, yo, this trial will probably last a week at most, you know, because of the type of information, though, how damaging the information was. I did not think it would go longer than a week. You know, and then they ended up interviewing like a lot of the police officers that was at the scene, that verified different footage, verified the times on a lot of different surveillance equipment and different locations. So, you know, I don't know, man. Hit the like button, hit the subscribe button. It just made a compelling argument. And us sitting there watching this guy, right? And the defense was trying to say, okay, well, if you look, you know, Bass Pro Shop that had some of the things that my client had on, anybody could wear that. You know, these are mass produced items, anybody can buy, but to have the exact same items on in multiple different locations and driving around in the cars, like, it's just insane, bro. You know, and then like we found out that, you know, there was not just a hit on Dolph. Big Juke wanted to take out the whole paper route. You know, so they were trying to figure out how much it was going to cost, like, per person, you know what I mean, per hit. So it was a lot going on, man, you know, and that's eye-opening to see the type of person that Big Juke was, or the vendetta that he had against Young Dolph. Like, yo, bro, you're going to do all of this, try to, you know, not only take Young Dolph out, but you're going to try to take the entire paper route out. That was insane. That is insanity to me. Insane to think about, you know, a person thinking like that. You know what I mean? So I don't know. It was just so much. And then, you know, Cornelius Smith revealed the FaceTime call with, you know, Big Juke, and them letting him know that what happened with Young Dolph was their work, and he's just, you know what I mean, like, basically walking us through the entire event, and then saying how they were sign languaging to Big Juke through FaceTime because he was around people. They didn't want to say it, you know, that the work that you were hearing about, you know what I mean, with a specific person, and then they sign language, you know what I mean, like Dolph's name. It's just like, bruh. Then we ended up hearing something that was very interesting, right? And, you know, Cornelius Smith is not technically on trial at this time. So, you know, I don't know whether or not he has some sort of proffer agreement, you know, some kind of agreement to where he can get up there and say whatever, and then it wouldn't be held against him. I don't know, but he told everything. One thing that he said that is interesting, that I think is going to come back to bite Yo Gotti, is that I think the defense attorney was asking Cornelius Smith, and he was just like, so who provided your defense? Because we found out that, you know, Cornelius Smith, like, he got ascertained, or got like $800 total from the hit. It was supposed to be a $100,000 hit. Cornelius was supposed to get, Mr. Smith was supposed to get 40,000. Justin Johnson was supposed to get 40,000. Govan was supposed to get 10,000 from each, which would have made up the other 20,000 as a total of $100,000. But, you know, Smith only got $800 out of everything. We even heard Smith say the unthinkable, like, yo, you know, I had to go to a meetup spot to get the other, you know what I mean, which he didn't know at the time it was going to be $300. He went to the meetup spot to get some more money because they had already gave him like $500. I think he had somebody that he calls his grandmother go ahead and like a letter be dropped off with the grandmother, like an envelope with the money or whatever, and he ended up getting from her. But later on, like, there was supposed to be another meetup spot because he kept hitting them up like, I need my money, like, where's my money? Hitting them up constantly over and over again, wanting his money, you know. So they finally decided, like, on a meetup spot, and this guy brought his girlfriend out, right? They go to the meetup spot. He have her put on a mask and sends his girl to the meetup to actually get the envelope or whatever. And then they found out it was like $300, which at the meetup, they could have, like, everything could have ended right there. Like I said, if this was an Italian job, you know, a popular hit, you know, they probably would have got like some young guys, had them do the hit, have them go to a meetup and then take them out. you know, but it wasn't that. Like, you know what I mean? They had a meetup spot for money, and it is what it is, man. So I think personally, the girlfriend, I think she needs to be locked up. My personal opinion. As far as, you know, the Mercedes Benz, we ended up seeing Justin Smith, who keeps claiming that he's innocent, right? We seen the house that the Mercedes was stashed at 2 weeks prior. Justin Johnson was doing a music video and shooting a music video at the house, right? So they're doing all of these different things to put Justin Johnson like around what's going on and make it clear that, yo, this is a conspiracy to commit a hit. You know what I mean? And I think the prosecution did a very, very good job, very, very compelling. But, you know, it's sad, like Young Dolph, I feel like I can't necessarily say he was a rising star. Like, I live in Tennessee, so, you know, where I am, you know, I hear about him all the time, like when he was alive. Like, I think he was making a lot of noise, you know, but, you know, this is statewide. I know, like, a lot of people respect him throughout the United States, but he could have been global, you know, and had a great, you know, situation like throughout his rap career, but that was ended short because these guys decided to do something ridiculous. We heard from Young Dolph's security. Prosecutor brought him up on the stand, and the security basically, you know, let everybody know that, you know, CMG, like they hit up Young Dolph's Sprinter van. Like when they got out the Sprinter van, you know, they got like notification that the Sprinter van was hit up, and they believe like, you know, CMG like ended up doing that. You know, and it was 100 shots to hit it. You know, the security guard talked about a different time in California, you know, that them Blicks, like, you know what I mean, that they had an issue, you know. So it's like, it's a lot that happened in a short period of time, I will say. But again, I think the prosecution had a very effective case. So what we're about to do now is listen to the closing arguments, you know what I mean? And this did not last long. I don't even think we got like a week out of this. Didn't even last that long, to be real.
All the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret.
Somebody said, shout out to the subscriber, Battle Rap Battery. He said, Dolph was great. He didn't make global reaching music though. You know what I'm saying? I don't know. I didn't look at the charts to see what he was doing, but I know, you know, it takes a while, man, to get a fan base, to cultivate a fan base, and to reach the masses, man. Like you're gonna see a lot of work being done by publicists. That's mainly their job, to like, you know, make extended reach. You see what I'm saying? Like put you on all of these different, like the DJ Academics, the Complex, to, you know what I mean, the Hip Hop DX, to put you around. Like the publicist mainly works your product, right? They're going to be shopping you around to make sure you get the most amount of exposure you have. But then you got management teams and, you know, things like that that's supposed to put you in different, you know, situations in different markets to bring you more visibility, you know. But, you know, Young Dolph, I feel like, was working. He had, like, you know, Key Glock was about to come up after him. Like, I think he had like a pretty decent, you know, following from, you know, what it looks like, you know what I mean? So shout out to Young. I mean, unfortunately he's not here, but, you know, he had a family. He was a family man. I think that was his downfall, you know what I mean, being a family man. And because with that, you know what I mean, not like with your kids or nothing like that, you know what I mean, but not being willing to leave Memphis. You know, I think that was his downfall, man, to be real with you. If I was Dolph, you know, we could say if I was, woulda, coulda, shoulda. Sometimes you need to leave. Like when you become a star around where you live at, you're gonna, especially a place like Memphis. Memphis is not like, you know what I mean, like what a lot of people think, man. Like this, when you watch the first 48, man, a lot of that is real. I mean, it is real. These are actual cases and things that happen. So Memphis, like I said, like in different blogs and stuff like that, man, I know people that, you know people that the cars and got jacked at lights and, you know, just silly, crazy things happening. You know what I mean? Just over there, like if you got an Infiniti, you got a Charger, a Challenger, like you in trouble. You know, but especially being somebody that is this notable, you having back and forths with Black Youngster, you going back and forth with Big Juke, who's obviously, you know, a real hitter. You know, in terms of a gangster, a shot caller, you know, that can have something done to you. You know, with that looming over your head, and I'm pretty sure he knew that there may be like something pending on him in terms of a hit, you know, because you gotta look at how he was riding, you know what I mean? Like he always had, for the most part, security with him, you know, and like with the Corvette, we've seen his brother Marcus, shout out to him. I think Marcus did an amazing job. Unfortunately, you know, it wasn't enough, like his brother's not here no more, but you know, he did enough to get them guys up out of there. Whether or not Cornelius Smith wants to say, oh, I didn't know somebody was, you know, like busting at us or whatever. Like he said, he didn't know up until they drove off. You know, then he, you know, or no, when he got in the car, he's seeing like rounds like that hit the car. And then when he drove off, like he figured out like something was going on, but he didn't want to, you know, bust back because he felt like, you know, he didn't want to hit somebody innocent. Come on, bro. Cornelius Smith don't have no type of remorse. Listen to him talk about the situation. I don't care. He can get up there and say all day long, oh, I got a conscience. No, you do not have a conscience, bro. You know what I mean? You don't have a conscience at all. Like to be in doing something like that. Somebody said in the chat, Young Dolph lived in Atlanta, but they caught him out in Memphis. He should not have been in Memphis, bro. You know, especially with them hot cars, you know, and cars using the music video. I think he even used that car, if I'm not mistaken, and like 100 shots. I think he might have used that, if I'm not mistaken, you know. But a lot of his music videos, like he used, like he had them cars is wrapped a certain way. And, you know, in Memphis, people are starving, people are hungry. They trying to get as much money as they can, you know. And like these guys, or I should say Cornelius Smith, he was saying, man, like I'm just trying to get some money. You know what I mean? Trying to find the best way to get. They look at this stuff as work. You know, and we found out that Cornelius Smith lawyer was paid for by CMG. So, because he said he only got $800, and I think his lawyer was around $50,000. So, because he did say, like, when he was talking to Govan or whatever, they were trying to let him know, like, man, you need the best, like, counsel possible just in case something happens, trying to tell him to get rid of the car, trying to tell him to get rid of the Blicks, like, trying to tell him everything. But then it comes out when the defense attorney is talking to Cornelius Smith, he's saying, you know, oh, so who's your defense? Like, you know, where did you get your defense for your attorney from? You know, was it like CMG? Like, did they give you? And then we found out, man, like CMG ended up paying for the attorney allegedly. I'm gonna put allegedly on that now, but that's what they said. You know what I mean? Like, that's what the defense attorney, like, that's what he found out. That's what he was like pushing the issue for, you know. And then the guy Cornelius Smith, he was like, yeah, I mean, like, you know, he didn't deny it. So I think that leaves CMG in a bad position. Like that Big Juke dude, I think created like a world, like a storm that could potentially come for, you know, Yo Gotti like later on. That's my opinion. But we about to listen to State versus Justin Johnson and listen to the closing arguments and everything.
It's hard to hide who you're talking to. It's harder to hide your actions.
Of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding.
Yeah, Marcus Chapman, the subscriber, shout out to you for being subscribed to the channel, rocking with us. You know what I mean? Hit the like button if you can. You know, that would be greatly appreciated. Also, you know, if you're new in the chat, please go ahead and hit that subscribe button. We've been breaking down a lot of different things this week, and we're going to continue to do it and move and talk about everything. I think I'm going to end up talking about Drake's girl, or the girl he was messing with. She ended up like messaging me or whatever, Johnny Blaze, you know what I mean? I may end up talking about that. I don't know, like, and mix that with the Cardi B blog, maybe, possibly, I don't know, we'll see. But y'all, go ahead and hit the subscribe button. Also, don't hesitate, if you want to, go ahead and send a super chat, and that'll be the quickest way to get my attention on what's going on. Shout out to everybody for tuning in. I know y'all on break, you know, some people on lunch, all that. Let's get to it.
surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who,
one thing that the judge did say before she started all this, because she just got to go, like, this is legal, right? So shout out to Easy to be, shout out to you, bro. Like, so a judge has to, before the jury goes ahead and deliberates, she's got to read this. So one thing she did say, which I kind of skipped that, and she was like, yo, like, don't take this as I'm trying to, like, I know you guys can read, I know you guys kind of understand what's going on, so don't think I'm insulting your intelligence. This is just, I have to read this to you, because this is a serious situation and this is legal, so that's what she said before she got into reading this.
Facilitation to wit aggravated assault. Any person who commits...
Hey, no problem, Daniel.
...the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the process.
And we also need to be really listening to this, because I mean, we heard what the prosecution said, we heard what the defense said prior to moving into the closing arguments, you know what I mean? But we do really need to listen to what she's saying, and that way you can kind of like gauge like whether or not you would have, you know what I mean, like found him guilty or not guilty.
Proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the aggravated assault. And that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct.
Also, real quick, because a lot of people been hitting me up, like, sponsors and stuff like that been hitting me up. Like, don't try to contact me through, I know they've got like a sponsor tab, like on Instagram. Like, just hit me up through Twitter, because I don't really use Instagram at all. It's like a fake algorithm, and it's only really made, Instagram is made for, I mean, shout out to the industry, but it's made for like, people that are in like labels and stuff like that. So you don't really see the feed of anybody you really know unless it's being, for the most part, marketed or promoted. So I try to stay away from Instagram the best I can. Twitter, the algorithm is a little bit, it is still controlled, but it's a little bit better. They give you a lot of latitude with Twitter to kind of, do different things. So just hit me up through Twitter.
When the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit, simple assault. Any person who commits the offense of facilitation to wit, simple assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or result of the result.
Hey, Diddy's baby, everybody that's watching, there's a subscriber in here. Shout out to him, man. His name is Diddy's Baby Oil. He said straight drop gonna need 1,000 bottles. Yo, you is crazy, bruh.
Of the offense. and that the defendant furnish substantial assistance to that person in the commission of the simple assault, and that the defendant furnish such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result.
Everything this dude did is intentional. Everything. I mean, I know you got to read this, judge, you know, shout out to you, you know what I mean? But everything this dude did is intentional. I think he going down.
Results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may.
Another thing, right? You know, like once they do all of this and the closing arguments, then you know, like the finality of everything is still not done, right? Like the jury's gonna go deliberate and all of that after the closing arguments and all. You know, they still got to come back and do the rest of it.
Readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence.
So Cornelius Smith presented direct evidence. He was involved. He admitted his involvement in it. He told everything that happened from his recollection. Everything ended up matching up to what he was saying. There's a lot of direct evidence right there.
Circumstantial evidence is all the testimony and exhibits.
But I am curious, right? And then we also found out one thing I do want to recall, right? When I talked about the Mercedes, we found out Young Dolph's cousin actually gave them the Mercedes that was used for this. That's insane, bro. That is insane. Like, that dude is never going to be able to go to like a Christmas or a Thanksgiving gathering again with his family. Can you imagine that? We never would have known until, you know, they can't tell us or disclose everything like through the media. Like, we never would have known some of this. One thing we did not know, right? We did not know that, you know, Young Dolph, his brother, was with him. You know what I mean? So, like, shout out to his brother, like, he was with him. And we saw, like, parts of the situation that happened. I'm amazed, right? And shout out to Young Dolph's brother. I can't say that enough. When Young Dolph's brother came out, like, you know what I'm saying, with the blick, and you can tell the slide was back and it was nothing else in there. How he was able to get that Corvette door open, I have no idea. Because, you know, Dolph was the person driving the Corvette. And so normally, like, when you drive a vehicle and you got, like a Draco in the car or something like that. Like, I mean, not normally, you know what I'm saying? Like, I'm a lawful person, you know what I'm saying? Like, I lawfully, you know what I'm saying? But if you got, like, a Draco, you said you can't hear, but if you got a Draco in the car, you know what I'm saying? You don't want the car door to be locked. I'm sorry, unlocked. So when all of this went down, because Dolph was like down the kind of like the aisleway, right? When all of this went off, and you know, his brother like came out through like the entrance, like trying to get them up off of Dolph. You see what I'm saying? And he ran and he managed to get that car door unlocked. So I'm wondering, because that was never really explained. Let me know if y'all can hear me. Let me know if the audio is good, right? I'm wondering, did Dolph's brother have a spare key to the car, like an extra key fob, just in case for emergencies, to where he can get to the car and get the Drake if he needed to? That's what I'm wondering, because like he did some John Wick to get to that Draco. You see what I'm saying? And then he started letting off when they was driving out. You see what I'm saying? So I don't know. Like, shout out to Young Dolph's brother, bro. You did, like, I don't care what nobody say. You like, you can live this life, you know, with your head held high. You was riding for your brother, and we all seen it. You see what I'm saying? We all seen it. There's no doubt. So I don't think you can, you know, live with like, you know, because some people, like, if you in a position like that, in a situation like that, your brother is not here no more, you know, that's probably going to be weighing on him, of course. Like, you know, nothing we say ever going to, like, fix that. You see what I'm saying? But I think he can, like, have his head held high, like, I did the best I could in that situation. That's my personal opinion.
Which give you clues about what happened in an indirect way. It consists of all the evidence, which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our law.
All right, Keenan said, he's a subscriber, he said, think he never locked the door. That could have been the case. That could have been the case.
Direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating the witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both.
Some people said, no, you said, did the cookie people set him up? No, that was a narrative that was going around. Yo, if the cookie people would have set him up, Cornelius Smith would have been on stand saying that. They didn't have anything to do with it. You know, but, you know, obviously, like, everybody's going to jump to conclusions on that, like, in the public. I even thought, like, yo, like, come on, bro. Like, how they catch you like that? Like, they had to have something to do with it. Like, no, they didn't. And I see something floating around on Twitter, right? So, like, people are saying, so the girl that was at the cash register when they walked in, right? The girl that was at the cash register when they walked in, she is on video, kind of like while they're there at the counter, she kind of walks off. And people said she should have alerted them to what was going on. But we ended up like looking at the video, right? And like in one of the videos that we did, like covering this, we seen like when she walked off, it was already smoke. So, you know, they was letting off, you know, so she like got out the way, like, because it was letting off. So it wasn't, you know, I see that circulating around on Twitter, but we already broke that down. Like, you know, the subscribers, the Jesus in here, like, you know what I mean? Like, we broke that down. We seen like, no, that was smoke, you know? So no, I don't think they had nothing to do with it, man. I think there was an unfortunate situation.
Party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to...
Hey, yo, we got 4,000 views in here. You know what I mean? Like, it's 4,000 unprocessed views in here. If y'all can't, hit the like button, man. Hit the like button, hit the subscribe button, man. We've been doing this for a while. Hey, yo, I'm trying to get to 100,000. Like subscribers, like 68,000 is cool. You know what I mean? We moved like 1,000 subscribers in like 2 days. You know what I mean? So like, shout out to y'all. But we gotta get, hey yo, I need that. We need that plaque. We need that silver plaque. Y'all need somebody else in the entertainment game, man. It's only like one or two people in the entertainment game, bro, that's even talking about things. Y'all need like somebody else. I'm the new kid on the block. You know what I mean? Rock with your boy.
Or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage.
Hey, shout out Mo for hitting the like button. Shout out to you, bro.
In the conduct or cause the result.
Diddy's baby oil shout out. He said you appreciate it. Hit the like button, man. Share the video. Yo, I'm saying I'm about to share the video. I forgot to share the video. We can't have, bro, you gotta understand, like the whole entertainment game is ran by like a few people. Y'all need somebody else in this game, bro. They ain't the only people that can do this. Hit the subscribe button, bro. They got hundreds of thousands. It's cool. We gotta get this channel up to 100,000. We not about to do that. You know what I'm saying? So subscribe to the channel.
The defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there
Also, y'all, we gonna end up talking about, like, after all of this, hey, yo, FBG brother, man, I rock with you. You know what I'm saying? You was supposed to come on and do like an interview, and that's my bad. But man, like, they caught you, like FBG brother, man, he got caught and he was crying at the police station, bro. We gonna have to watch that. We gonna have to watch that, FBG brother. Hey, I rock with you, bro. We gotta watch that in a different video, man. Like,
there was such a witness and whether such an inference has arisen.
Somebody said what caliber got Young Dolph, so it was a 40 hand, you know what I'm saying? Like one of the Blicks, a handheld, and then they had a 7.62 by 39 Draco. You see what I'm saying? So they didn't specify, from what I can hear, like what model, you know, but like they got the rounds that was recovered. And then there was also 223 shells that was at the scene, but those were from Dolph's brother. Because remember when he got to the Corvette, he pulled the Drake out the Corvette, and then he start like capping off, like trying to get him, you know. But another thing I do want to say, I think I failed to mention, Marcus, Young Dolph's brother, he ended up hitting both of them. He hit Cornelius Smith twice, and then he hit Justin Johnson once, which was a graze, you know. So they ended up getting med packs, like once they got to their destination, and they swapped cars, got med packs, got back to their destination. You know, the other dude, Cornelius Smith, he, you know, realizing he's hit, they call around to get, you know, med kits, and we seen Justin Johnson like getting the med kit out of the Charger at the apartment, you know. So like all of that went down, you know what I'm saying?
Is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so.
I think he should have took the stand. What do y'all think? I think he should have took the stand, bro. Or do you think he's so silly minded that where the defense was probably worried that the prosecution would kind of get him, you know, get him out of his zone, probably get him upset just to show the jury like how he can get upset, you know what I mean, and shot, you know. I think he should have took the stand. Like when you have Cornelius on you like that, you know, telling everything, and then you got like even the defense attorney not calling objections to obvious objections, because I seen some of y'all in the chat, a lot of y'all are hip of what's going on. Y'all like, why is that not an objection? Because you know, the only objection I've seen the defense attorney really make is when Cornelius Smith was talking about the reason as to why he decided to cooperate with the authorities, right? Because he said Justin Johnson ended up sending him a letter, and in the letter he was trying to go into the details of the letter, and that's the letter is the reason why he made the decision he came to terms with everything, and then he made the decision to cooperate, and that's when. You see what I'm saying? The defense attorney called the objection because it's hearsay. But Cornelius Smith was up there saying a lot of hearsay. He was saying what, you know, people were saying and thinking, and, you know, all that, like Big Juke saying what they saying, and Govan and saying what they saying what different people are thinking, and, you know what I'm saying different people are putting hits on people, and like he was saying a lot of like hearsay, and the defense attorney was just allowing him to rock. So that's why I'm like, yo, is the defense attorney kind of on the prosecution side at the end of the day? And then we know that Cornelius Smith, he had a lawyer that was provided to him, allegedly, I'm going to say that, but he didn't deny it when the defense attorney pressed him about it. He had a lawyer from CMG that was like a $50,000 lawyer, right? So what kind of lawyer does Justin Johnson have? Is this a paid lawyer, or is this a court-appointed lawyer, is what I'm curious about.
cannot be considered for any purpose against him, nor can any...
Yeah, and then Keenan said the lack of objections, the defense part is crazy, bro. It was crazy. And then Emma Magazine, she said he's a court-appointed defense attorney.
Any inference be drawn from such fact. Stipulation. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County.
You see how she just looked at them, making them remember, okay, he is a convicted felon. She is on the side of the prosecution. Don't let none of this fool you. With the justice system, she is on the side of the prosecution. Her job, remember she was leading the prosecutor? Remember when the prosecutor was trying to say, I got this camera from this time that shows the defendant. I've got this camera with this time that shows the defendant. And she was saying, okay, well, how am I supposed to know that both of these cameras, like, how can you show me that these camera times are correlating with each other? Like, she was guiding the prosecution at one point, because what they have to make sure is that there is no way this can be appealed. They can't leave any stone unturned, because she doesn't want her decision being appealed. She knows this is a landslide case. There's nothing that this defense attorney can do to save this guy, right? But oftentimes later on down the road, for whatever reason, you get some, like overzealous attorney that can come in there and find some kind of reasoning, right? It can be just something off of a technicality that can get him out. And so they're trying to make sure they're sewing up everything to prepare for the verdict. You know what I mean? So she was guiding the prosecution at one point. So when you see her looking at the jury, and she's saying like, yo, he was, he got a criminal record. He was, she's looking at them, letting them know like this dude, he ain't like a nice guy like he look. Think outside of the box with this guy. Don't let this guy sit here with a polo, you know what I'm saying, or a button up. Don't let that fool you. He's got a record. And when she looked at them like that, I know that probably like signaled to somebody, okay. So you gotta pay attention. It's the things that are not said in the courts that you gotta look at.
Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight.
Hey, yo, you all crazy. Hey, chat, y'all crazy. All right, I see Chrissy. She back in here. Shout out to Chrissy. Said he should have worn glasses. Innocence. Y'all crazy.
Together with all the other evidence when you decide the guilt or innocence of a defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of
y'all crazy. Make sure y'all sharing the live though.
Case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so.
But y'all also,
to
you got to think about the pressure that this judge may be under. You see what I'm saying? Like, imagine like she's in Memphis, right? Or whatever, because they have people from like jurors from Nashville to come in here. So with a person like Dolph in Memphis, like I know she knows the weight of all of this. You see what I'm saying? So imagine the amount of pressure this lady's under. She knows like, yo, they about to be talking about this in the media, in the news. You know, I gotta play this as best as I can, because if she makes a mistake during all of this, they own her. And I think she did a pretty good job. Like, yeah, she was leading the prosecution, but I think this is one of them cases where, you know, a lot of times like the culture don't like this system, the whole system at hand. We don't like the system, right? But under certain circumstances, like a circumstance like this, I think we all kind of riding for the system in a sense. You know what I mean? Like, for them to get this right, this dude is clearly, he did this. You know, so we not really, you know, if this was something else, we probably be looking at it like, oh, she leading the prosecution. But, you know, people now, they're like, nah, bro, like, whatever she do, like, we good as long as he get locked.
Judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict...
Hey, y'all, like, y'all know Quavo from the Migos? He just got ordered to pay $700,000 to a valet driver. Did y'all know that? So it says Quavo has been ordered to pay a man named Antonio Henry, a former valet for the Encore Hotel and Casino, almost $700,000 after slapping the worker in 2018. And it says Henry claims he sustained physical and emotional injuries and sought compensatory and punitive damages. Wow, which he's been granted following a multi-week trial. So it might be the move to make somebody mad and, like, you know what I'm saying? Like, get them later. Yo, that's crazy. Imagine coming off like, yo, so you probably about to see Quavo drop some more music or do some more concerts to make that 700,000 back. Like, that's insane. That is insanity. Was it worth like 700,000 to do that? Y'all gotta ask yourself, but y'all also gotta look at this, bro. People gonna try you when you a celebrity and all that. They gonna try you. You see what I'm saying? And you know they get tried on a regular basis a lot. And after a while, you just like, remember 50 Cent? Shout out to 50 Cent. He was chilling with his girl. He grabbed a chair like. Because people will they'll try you and they'll make you like get to that point. But Quavo, bro, $700,000. And yo, shout out to T.I. and Tiny. They ended up getting $70 million in an intellectual property rights suit that they ended up winning. You know what I'm saying? So shout out to them. They about to $70 million richer. They already got bread, but $70 million richer. You know, so shout out to them. Like, music industry is something else, man. Y'all can't just like, you can't just take people's stuff because they can get compensated for it later. So a lot of people that have been talking about Tiny, remember when all the We ain't gonna do Tiny like that. Shout out to Tiny. She got 70 million. She might come after me. Now, hold on. Let me let this play for a minute.
You should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included.
I'm not gonna do that to Tiny because Tiny, y'all was going in on Tiny at one point. Y'all was because the T.I. had the camera and it like the camera flip and you seen her and everybody was trying to roast her. Bro, I bet like now that y'all know she got 70 mil, she probably looking a little bit different to you now. Yeah.
Offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Hey, what you mean? Hey, why y'all keep bringing up this y'all entertainment people? Hey, why y'all keep bringing up Young Buck, bro? Like I ran down on him like years ago, bro. I let that go, man. Y'all crazy.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case.
Another thing is, so Costco responded to Diddy, right? Y'all want to see it? Let me go on Twitter. Let y'all see this real quick. Yo, let me let y'all see this, bro. Let me take y'all to my Twitter real quick. All right, so Costco responded to Diddy's lawyer, right? So they basically saying that they don't have 100,000 bottles. I'm sorry, 100,000 bottles. No, they don't have, like, they don't sell baby oil like that. You know what I'm saying? So I think they said they don't sell baby oil. That's what they were saying. The salesperson at Costco TMZ, no. Yeah, they don't sell baby oil. So they not playing with Diddy's lawyer, bro. Hey, y'all, hit the subscribe button. Hey, they not playing with Diddy's lawyer. They letting it be known we don't sell baby oil. Like, you can't just come here and get 1,000 bottles of baby oil. It don't work like that. Because you know how people are. If something becomes popular, they going to try to do it. They going to try to get that baby oil, whatever they can do. They want to. So they saying like, yo, nah, it ain't. We can't be, y'all can't be saying that, bro.
And earlier this week,
and just in case y'all thought I was joking, no, bro. All set, bro. Double XL. Quavo has been ordered to pay a man named Antonio Henry, a former valet for the Encore Hotel and Casino, almost $700,000 after the worker in 2018. 8 News Now reports. Henry claims he sustained physical and emotional injuries and sought compensatory and punitive damages, right? And then it says, which he's been granted following a multi-week trial. Bro, it ain't even worth, you know, like how a person be thinking like, well, a person like me or something, right? I would be thinking like, man, if a rapper, me, you know what I'm saying? Like, hit me with one of them, bro. I'm like, oh, what's up? It's up. But it looked like the way to really go about that is to turn the other cheek and to call your lawyer. That's what it looked like. I don't know if I could do that, man. A lot of us don't have that willpower. It said his name is what? Like, shout out to him. It said his name is Antonio Henry. So I don't know. Like, is that a brother? Because a brother ain't just gonna sit there and let that. And you know, Quavo ain't like a big dude. So if Quavo was to try that, you know what I mean? If Quavo was to try that with one of us, like, nah, Quavo, you gonna have to, somebody gonna have to wake you up. Bink, bink. You know what I'm saying? Like, that ain't about to happen, Quavo, bruh. Can you imagine Quavo? Like, I mean, shout out to Quavo. You know what I'm saying? Shout out. I ain't got no problem with you, bro. Imagine Quavo. You know what I'm saying? Like, what you say? What you say? Bink. Nah, Quavo, you gotta chill. Like, y'all be letting this money and stuff get to y'all. Hey, Quavo, you gotta chill, bruh. You gotta chill. It ain't worth it, man, because, hey, people ain't playing fair. And we in the era, Quavo, like, people trying to make an example out of people. Oh, you got to chill. You got to chill.
You heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all this—
Yeah, now that I think about it, hey, a subscriber, like, shout out to the subscribers, everybody in the chat. If you watching now, subscribe to the channel, man. I react to my chat, right? So somebody said you should have let Young Buck steal on you. I should have. You know what I'm saying? Like, being around, be like, because I ran down on Young. I'm like, so what's up with you and 50 or whatever? But Young Buck, like, small. Like, I'm a big dude, bro. You know what I'm saying? Like, I'm pretty big, right? Bro, just the optics of, like, Young Buck, like, that would have looked crazy for me. Like, you know what I'm saying? Like, man, I'm just letting this little dude. But I should have been like, what's up with you and Fit? And then he would have hit me, you know what I'm saying? And then I would have been, he hit me. Then I would have went downtown and got somebody. Young Buck hit me, help me. And then I could have got paid, man. Like, you right, man, I should have did that.
Those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder.
Hey, yo, why is this guy that I know on Survivor? Yo, that's kind of crazy. Like, Survivor, really? Like, come on, man. Like,
2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us and he told us that he met Justin Johnson.
Hey, you already know. He said, yeah, Rome DMV. Go on my Twitter, bro. I just retweeted it. Hold on. Like, shout out to everybody, bro. Like, I just retweeted. I'm not lying, bro. Hold on. Look, bro. Rome DMV is all like Survivor, bro. Like, what? Nah, bro. Yo, that's crazy. Yo, but if he get $1 million, yo, hey, I'm gonna hit him at like wrong, bro. I'm gonna need like $10,000. You know what I'm saying? I'm running down on you, bro. Like, it just went like, you gonna have to give me. If he win that million, I think we following each other. If he win that million, bro, you got.
And that he knew Justin was a rapper.
I'm gonna run up on Rome DMV like, hey, Rome DMV, like what you got on my 40, homie? You ain't gonna do nothing, Rome. You ain't gonna do nothing. Rome DMV gonna be like, I wish you would. He gonna be like, Rome hit me, Rome hit me. Going downtown. I'm gonna get that $1 million. You know what I
Also
mean?
known by the name of Straight Drive. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify the defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Joke had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements.
Cornelius Smith? Bro, he's never gonna be. Yo, can you imagine Cornelius Smith and PC after all of these facts? Telling everything, the $100,000 hit. There was an agreement made to Dolph. The plan had been in process for weeks, which aids to premeditation. Defendant was an active participant in the agreement, and he testified to that, like, with no defense objections. Like, come on.
So there we have it. A conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is, one, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake.
Yo, that is a lot of things they gotta prove. I didn't even realize that. So the law of first degree, definition of premeditation of another. Defendant unlawfully, the victim. Defendant acted intentionally. Was premeditated. Like, what?
There was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in Gore Dyer last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car. You held up your hand.
Yeah, but you got, hey, Mo. So Mo said, subscriber said, I don't understand how he said, I don't understand how you know you getting 25 years and still, yo, what is going on? Like, bro, like, I'm getting old. My eyes ain't working. Like, help me. Like, yo, I'm like, you know what, like, hey, yo, when you get old and your eyes they not work no more. Like, bro, we were just live. I was reading this whole thing. Next day, I'm like, nah, bro, I need glasses. Like, oh man, bro. He said, I don't understand. Hold on. He said, I don't understand how you know you getting 25 years and still tell to bring the team down is nasty work, right? I'm gonna say this. The lawyers may have worked something out to where it's like, man, like, this is how it's going to look for right now. Once we can secure this conviction on Justin Johnson, then, you know what I mean, we'll move into this spot to maybe reduce, like, what we going to end up, like, hitting you with. You know, so, but we're going to need your full cooperation. When you go ahead and you get on that stand, I don't want to hear you ain't Lil Woody. You Cornelius Smith. Do not play that Lil Woody situation with me. You gonna tell us everything. I want to know everything. Right? He got up there. He said everything. So when they go back to the table, right? He could be like, his lawyer can be like, you know, he went on stand. You got the conviction. He went on a stand. He didn't hold back. He told you everything you wanted to know. What are we doing? You know, and then they can, you know what I'm saying, like make the arrangement, but they can't make an arrangement before his, you know what I'm saying, he gets up there and he testifies, because then the defense can be like, oh, well, you already made an arrangement. And that can add, you know, to the defense's argument that this guy's opinion or recollection of the counts, you have to take with a grain of salt, and he's not, you know, there's no validity to what he's saying, because there's already been something that has been agreed upon between, you know, Cornelius Smith and the prosecution. But the prosecution smart playing it, like when he had Cornelius Smith on the stand, he was asking, he was like, did I promise you anything? And Cornelius was like, no. And he was like, well, didn't I tell you, like, even if you keep it honest, you still going to jail? And he was like, yeah. He was like, didn't I tell you that, you know, if you tell the truth, you're not gonna walk out of here like that? And he was like, yeah. So, I mean, he covered all bases so that the defense attorney couldn't use that to his advantage to say, well, you guys already had a pre-arrangement. Of course, Cornelius Smith is going to say something because he's getting something out of the deal to put, you know, reasonable doubt into the jury's minds. You see what I'm saying?
You pointed a gun and you shot and killed somebody.
Shout out to Cassandra. Hit the subscribe button.
As long as you had a moment to think about what you were doing, that's premeditation. Next. So we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. Because
remember when the victim's sister, like, they brought up, like, I guess they had signed something, the defense and the prosecution had signed something with Young Dolph's sister. So it's basically admitting to the facts of whatever happened or whatever the autopsy revealed, so that she didn't have to see the video or an image of it. You see what I'm saying? You remember that? Like, they were like, oh, well, there's something that was agreed upon, so she doesn't have to see the photos. You know, because she don't want to see her brother like that. You know what I mean? And then be looking at the dude that did it. You know, so they had an agreement in place for that. But she basically just testified because they asked her a question like, yo, do you miss your brother? You know, and then they, you know, basically just, you know, let people know like he was a living person, and just, you know, it's what it is. I mean, it's obvious he was a living person, but it's what it is.
There was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and...
This is insane, bro, to hear her say that. That is crazy, man. Like, some young dude can just out of nowhere and do that to you. You working, you trying to build something for your family, and some random dude. Well, I can't even say he random, right? I can't say that because, you know what I mean? Like, he was, I think he was around Dolph, right? Because I posted a picture. Let me show y'all this. So I posted a picture on my Twitter, right? If I can find it. Yeah. This picture. This is Justin Johnson. It's, you know, a lot of times, man, like, you don't know who you around. That's why people choose to keep their circle small. You see what I'm saying? I mean, he may have just been a dude that was there. You know what I mean? Like, you just never know who you around, bro. That is crazy.
Vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makita's video. And he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about.
Hey, hit the subscribe button, hit the like button, man. Come on, man. Give me to 100,000, man. Y'all playing, man.
He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car.
Remember, they were saying they were trying to catch one of them. They knew he was going to eventually like go to a turkey drive, but they were thinking that they can catch like any one of the people that had the money on their head, you know, at the turkey drive. It's crazy.
It tells us that they followed the car, made a loop onto a back street, and then entered the Makita's parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makita's. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care.
Hey, y'all that's watching this, bro. In the chat, there's this dude named Diddy's Baby Oil, and people are like atting him. And so I see all... So like when they, you know how like when people at each other, so they atting him in the chat. So in the chat, it's a whole bunch of like Diddy baby. Y'all crazy, man.
They change their clothes and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well actually let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or that
like people don't be understanding. Like even if you get a rental car, bro, like detectives are gonna check to see like if a rental car was like rented around the time. They're gonna check the camera footage of the rental car place. Like, what are y'all doing? Y'all gotta think, man. Like
a few hours after the cars were switched. Similarly, DeMarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. 40 caliber, attributable to a handgun. 7.62, attributable to an assault rifle that Cornelius Smith had. 2.23, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the 40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Makita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning.
That was the, oh man. Look at all this time this dude wasted. Yeah, I mean, it's like a week, bro, but you got court reporters up there. You got different lawyers up there that got to get paid. The judge got to get paid, the court time. Man, this dude.
The timestamps on Gospel Garden and Makita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time, the kissing Garner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m.
Yeah, hey, Keenan, hey, in the chat, hey, prosecutor did warn him, didn't he? He's like, this ain't 1981, this ain't 1991. There's cameras everywhere. We know where you been at. hey, Keenan said prosecutor tried to tell him they will find you like Liam Neeson. He tried to tell him, no.
On November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Akiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelius Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs.
Hey, yo.
And now it's time for you to consider.
This prosecutor right here, she's boring. She's not even the prosecutor that was really, I guess she was like on the case. We just didn't like really hear from her at all. We heard from the other boring dude. But the other guy, I think, should have been the one to do the closing arguments. I think it would have been a little bit, no, she's faster. She talks faster. No, I'm like, she's good for it. I mean, he was basically just going to go over the timeline anyway. But like, I would, because, you know, people still be trying to like not really find people guilty and all, you know what I'm saying? I would be up there. Yeah, like they boring. Like I'd be like, they're like, look, we told y'all everything. Listen to me. Did you hear what he done said? Did you hear what Cornelius Smith said? Listen. We not playing with Cornelius up in here. Listen to me. I need y'all to look at that evidence. That everybody I brought in here, the TBI investigator, we done pinpointed everything. Listen, like, bro, I will be going off in there, bro. I'm not about to be boring. Like, I don't know, like, maybe they just been like so much research and everything. They bored, like slideshows and man, I'll be up in there wilding. My closing arguments is gonna be dynamic. They gonna remember me. Like, listen to me, y'all. Like, look, wake up. Like, we not, this ain't no time to sleep. Y'all want this dude on the streets or not? You can't even get cookies with him around. Cookies is off limits if he on the streets. Like, I'll be wilding, bro. They gonna wake up with me. The closing arguments. Don't be letting that defense attorney try to trick y'all. I'm sorry, defense attorney, but don't be letting him try to trick y'all. Listen to me.
Hear that evidence and apply your
I would have had a jury like, listen.
And after you do that, I think, well, actually, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Steph.
Thank you, Judge. It's good to see y'all again.
All right, we can kind of put this normal because he speaks like regular.
This is the last time you're going to have
This is the defense attorney.
to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case.
All right, my bad, y'all. He being boring, bro. We not about to do this, bro. You're not about to bore us, bro.
But it's heavy. Now, on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. engaged in a.
Hey, Keenan said I did not like his defense tactics throughout the case. I think he had a good opening statement, right? I think he did. He tried a little bit when he was interviewing the cop, right? One of the officers, and he asked him a question because they were talking about the times of the recordings. That I think they were talking about the recordings that saw Justin Johnson at the elevator with, you know what I'm saying, like his little one, you know what I'm saying? And with that, like he was trying to say to the cop, well, how do you know that the times are accurate? You know what I'm saying? And then at this location, how do you know that the times are accurate? Like, were you there? Did you calibrate the, you know what I'm saying? He's like asking, so he's trying to say that Justin Johnson could have been wearing what he was wearing at different times. Is it possible that could, you know what I'm saying? He was about to get around to that. No, there was nothing he could do. I would be with, you also got to think, they got to make money, right? And some people want to be a prosecutor and some people want to work on the defense side of things, right? You got to have both in the system. But if you have a client that is this outright, like when you get to discovery, and you find out all of this information that they got on your client days prior or hours prior, wearing what he was wearing like during the hit, and then you got like information showing like the Mercedes, you know what I mean? Like everything's being linked up to your client, and your client doesn't want to take a deal. I would sit down with my client like, bro, you got to let me go. As an attorney, you got to find another attorney. This would at least buy you some time to find new counsel. They may continue it a little bit, but you may need another attorney because I'm advising you to do something and you're going against my advisement. You see what I'm saying? Somebody said Piper Boy turned bro voice into Twister. I mean, I had to. He's being slow. You know what I'm saying? So, like, if you're a defense attorney and you have a big case like this off of a high profile guy, part of it is like, you don't really want to win this because you live in Memphis. You kind of don't, you know what I'm saying? Like, let's be real. His defense attorney really living in Memphis and seeing he know what happened to Juke. And he see what just happened to Dolph. You see what I'm saying? So, hey, sometimes he could have caused some objections, but he might be thinking, this is us breaking it down. Like, we all, you know what I mean? We got to read between the lines with things, right? He might be like, hey, is it really worth me objecting to everything? And then I got to go to the grocery store. You see what I'm saying? And people might not like this of me doing too good of a job on this case. So maybe on this case, I'm not going to do that good of a job. But I would have tried to get off of the case. If I'm not going to have a compelling argument and try to save my client, you know what I mean? And I see that there's nothing I can do with it, I'm off the case. I'm going to tell him, like, you need to, I ain't going to hold it against you. Find another lawyer. Or take the deal. They're always gonna low-key try to bully you into a deal. They don't want to do a drawn-out case. They don't want that. That's taxpayers' money. They understand if you lose this situation, your whole life may be gone. Like you can potentially get the max. They can put it up to the jury. You know what I mean? So you gotta think, but your client's not thinking at this time. You might need to get off the case. Keenan said, never thought about that, but that's facts. What transpired with Dolph, he might be shaking in his boots. Exactly. Then you got, hold on, bro. You see how CMG get down. So it's a lot of, I mean, I know the CM, you know what I mean, the dude, Big Juke, you know what I mean, hired these dudes, you know what I'm saying? So it's a lot to think about. These like hoodlums, they not like the mafia, like the real ones. You see what I'm saying? Like the Castellanos and all, like Them the real the dogs, right? They get you going like in a different way. These dudes will ride up on you and not even think about the consequences. So this guy right here, we may be looking at him, you know, and we was kind of having fun like throughout the days, like, oh, this dude, he ain't even objective, he ain't even, but if I'm this guy, like, you also got the bar you got to worry about, right? Because he could be reported to the bar, investigated and all that. So he got to be thinking about himself, you know, so he can't just fire himself. I don't think you can do that as a lawyer, if I'm not mistaken. Like, recuse yourself from the case or whatever. You got to try to get your client to, like, get rid of you. You know, so, but like I said before, I mean, we're going to get back into his closing argument. Would you really want to win this case? And you live in Memphis, dog. It's small in Memphis. I'm not trying to win this case. This ain't something y'all want to hear, but if I was a defense attorney, nah. You think that judge don't know what's going on? Because normally a judge will kind of like, they're going to ride with they're going to try to lead the prosecutor sometimes, right? Sometimes you might get an impartial judge that kind of just want to see like a good case presented, right? So they might be looking at the defense like, you going to object, you know what I mean? But I think they kind of understand that the circumstances here, this is not, you know, the defendant can get off and then they can just go be chilling outside of Chipotle eating and think nothing going to happen to them. You know what I mean? Because then they would be part of the problem. Like, Memphis loves Dolph. Don't get that confused. They do. So we see how much they love him. We've seen the big juke situation. You know what I mean? So he got to think, bruh. Justin Statham up here talking, whatever his name is. Do look like Justin Statham, the lawyer. You know what I'm saying? he got pretty much got kids. He got to think.
Music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make, beyond a reasonable doubt, is the heaviest one. Maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case.
Subscribe to the channel. I'm losing my voice. Subscribe to the channel.
You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully. To listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith in that conscience, right? Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience.
Remember I said that because I don't believe that either. But I mean, I believe, regardless of why he ended up telling everything that happened, I believe Cornelius Smith about what happened. I think Justin Johnson had everything to do with that.
And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Ford Jr. He didn't conspire to kill Adolf Hitler.
Yeah, AG2, he said, is he preaching or pleading? This defense has nothing. Nothing. And I think they have nothing purposely. They want to go home. They don't want to worry about this. They wanted one of these thug life people like walk up to them. They want them to be like, thank you. They don't want to be looking over their shoulder.
And he wasn't
It's politics.
the man holding the pistol in the Makita video. And it's going to be up to you to decide that. To watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar, it doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it, other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat.
Man, get out of here, defense attorney, bro. You're not about to do that. We heard like Gwen Stefani having Bass Pro. Like, man, get out of here, bro. Ain't nobody wearing the exact same outfit as him the time that happened. A Bass Pro Shop hat. No hood dudes, they got fitteds. They don't have no Bass Pro Shop hats, bro. I know Bass Pro Shop got a big shop in Memphis, but they hood dudes. You would get clowned for having a Bass Pro Shop hat, bro. He had we not doing that, bro. He don't care what no Gwen Stefani was rocking or wearing about, like, no, you are throwing this case away because you scared and you want to go to Starbucks without being worried. This Bass Pro Shop stuff you talk, like, man, come on, bro. This dude think we 3 years old, man. Like, oh, Gwen Stefani, she's got a Bass Pro Shop hat. Like, what? You think he's sitting around listening to some B-A-N-A-N-A-S? Like, what is up with this dude, bro? This is the wrong culture. You don't... No, I did not just get up here and say B-A-N-A-N-A-S, like, bruh.
You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson, and said that person always wore a Bass Pro hat.
That is something, bro. Like, I wish... This bananas, B-A-N-A-N-A-S. Like, come on, bro. Like, that was the weakest. Like, come on. You know this judge is trying not to laugh, bro. What is he talking about? But he did say something. He was like, oh, remember, like, somebody else, mentioned somebody that had a Bass Pro Shop hat. You know what I mean? That was another suspect. That's kind of, you should have, like, touched on that. Like, why didn't he even say anything? Well, we already know why he didn't say nothing about it in the trial. You know what I mean? Try to be safe. But he could have brought that up, like, during everything, and then, like, interviewed the person. You know what I'm saying? He could have did a lot of that to present doubt. He did not want to present no doubt. You know what I'm saying? Or bring witnesses for all of that, bro. Like, come on, bro. This dude tripping, bro.
You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Two Lane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree. Right?
Hey, yo, we just had somebody come in the chat, bro. Like, yo, the chat is like terrible. They was like, yo, Piper Boy Williams is DJ Academics from Wish. Man, I blocked you, bro. Don't be. I can't stand y'all, bro. At least give me the Timo. Y'all is bugged out.
You know, we got cameras, but like I told you in opening, what also has advanced tremendously.
We ain't doing that. Hey, Academics, I ain't coming at you. You know what I'm saying? You shared one of my videos before. I'm not, hey, we good. You know what I'm saying? But my camera better than Academics, bro. Like, Academics, like, hey, I got you on the camera. The camera better. Shout out to Academics, bro. I blocked, dude. You not about to come in here and call me Wish? Oh, he don't wish Academic. I'm like, come on, bro. We ain't doing that. Block.
Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not.
No, this dude did not call me DJ. We not doing that, bro. Dude, you're not gonna come in here and call me. Hey, you know what? Somebody kind of get you on something, and you trying to ignore it. You like, man, no, you did not just try to call me a witch. Like, come on, bro. Hey, y'all, my chat crazy, bro. I'm telling y'all, my chat is crazy. If you join this chat, you about to join like the crazy squad, bro.
In a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA.
And this video better not go viral when y'all trying to like clip up me reacting to somebody calling me. Let me stop, man. I'm not messing with y'all, man.
They found one of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in his Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building, or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown, and when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, "That's not me in the video." And he's like, "Okay, it's me." But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson, and that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Chris.
What y'all think about that? Is he putting doubt out there? You didn't catch Justin Johnson getting in the Mercedes. Bro, I just say, like, what is you talking about, defense attorney? Like, bro, Justin Statham is wilding. Look, I seen Justin Johnson do the, I'm not laughing at the Dolph situation, but I seen Justin Johnson do the hit. I seen them run back to the Mercedes. What are you talking about? What is he talking about?
That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Ford Jr. Their prints are in the car. He says they have, he said a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? Indeed. Why couldn't he just say, I don't have anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, with a phone using, a tower that could be, and he said could be, he said was in the service area of the Valero gas station, or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, all right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time, immediately after Adolph Ford Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be.
Bro, we seen your client with the clothes on. We seen him after getting a med pack. I don't want to hear this. What they call that in Call of Duty? When somebody drop a med pack on you? You know what I'm saying? Like a airdrop. Do we seen him get an airdrop? Like, come on, bro. Changing clothes. We see the guy that admitted to doing it. He walking with him like right after it when he popped up. Like, come on, bro.
Anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened, and he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was,
Would y'all convict Justin Johnson right now? Press 1 in the chat. If you would not convict him, press 2. So if you would find Justin Johnson guilty, press 1. If you think he would be innocent, press 2. Let me know.
he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it.
Y'all put them ones up quick. Hey, AG2 1, Malk Sinatra 1, Rico 314 1, 19 9 1, STU 1, Keenan 1, Cassandra 1, Danny 1, Corey Jenkins 1, Vaughn 1, Angel Roses 1, STU 1. Derek said 1, and I live in Memphis. STU 1, 111, E4 1, Marcus 1. Bruh.
And Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told. He had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth.
Hey, yo, this lawyer freestyle. Hey, we got 16,000 views so far, man. Shout out to everybody, man. We still gonna listen, man. But y'all hit the subscribe button, hit the like button if y'all can.
No. But you remember, and it was kind of an interesting moment when he was testifying, because at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom.
Hey, yo, they giving this defense attorney mad time, bro. He been talking so long, I'm starting to think. I'm starting to kind of think about stuff, bro. Like,
and I asked him, I said, you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Services rendered, right?
Hey, yo, he said he got a Geechee Gotti round. Y'all is crazy, bro.
And the lawyer, he's talking about with his sisters. He's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer that got the cooperator from Holly Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500, and then some other time some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was?
Yeah, I know, right? Like, hold on, we all in the chat smoking the defense attorney, right? Like, we smoking on a defense attorney pack, right? And the more he talks, the more I'm like, wait. I mean, we don't really have no evidence that Justin Johnson and got money. Wait. I mean, when they was, you know, I'm starting to think, bro, like, I don't know, man. This, like, these attorneys are sneaky. Like, if I was the judge, I don't know, how do they decide who go first or not in the closing arguments? Because I think I think it was the same. I think the prosecutor opened up the opening arguments and then the defense went second, right? So I think they just doing like the same. Maybe they flip a coin. I don't know. But he got one of the rounds now. Like at first I'm like, man, get out of here, get out of. Now I'm like, I mean, if I'm a jury person, I would be thinking like I just seen him take Dolph out. I just seen it. You know what I'm saying? The video and everything. So he did it. You know, but the way the judge, remember when she opened everything up and she was like, look, I'm not trying to, play on anybody's intelligence or anything. I know you guys already know all this, but I have to read this as a formality, right? And what to consider with certain different things, you know what I mean, that this guy is being charged with. So I don't know, man. Now that he's talking, because I would have to sit there and look at the, like, what they got to decide on and everything. But to be real, like, I mean, I would still say he guilty. I would still say that, you know what I mean? But I mean, he is making me think, you know what I'm saying?
The state asked him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing.
And y'all gotta think, bro, we was at 1.25x speed, right? So, like, this was even like, he's still talking. This is even like that much long. Like, if we were running normal speed, like, he probably like giving like a 35-minute like round, a 40-minute hour round, saving everything that he could have did like during the trial into the closing arguments. So it looks like this guy's strategy was not to bring witnesses in, you know what I'm saying, or professional witnesses, right? Professional witnesses cost what? You see what I'm saying? And Justin Johnson obviously is in a position, I'm sure he's not going to be paying a bunch of forensic professional witnesses a lot of money. Like, if Justin Johnson was like a millionaire, this would be a completely different trial, right? Because then they would be able to get like a professional witness from the coroner's office. You see what I'm saying? A professional witness from, you know what I mean? A forensic witness, you know what I'm saying? Like that. But you got to pay for the professional witnesses. They don't sit up there for free. The state has the ability to do that. They can get the TBI guy. They can get all like they can get all your phone records. They can do anything, right? But when you talk about professional witnesses, that's going to cost money. So it looks like this guy's strategy, from what it seems like to me, and this is all of us watching, you know what I mean? We all look, we thinking outside of the box here. If I'm looking at this, he probably like, look, we don't got the money to be having no professional witnesses. So the job I'm going to do, don't think I'm not doing no work for you, because I'm saving everything for the closing arguments. It doesn't matter what I say right now, because you got a lot of information against you. Right? I told you to take the deal. You didn't listen to me. Right? You wouldn't. So, but this is the game I'm going to play. The closing arguments, we're picking apart the prosecution. That's the best we can do. That's our best shot. And I'm talking last. I'm going to put as much reasonable doubt into their minds as I possibly can, in hopes to get you, you know what I mean, not necessarily off of this situation, but maybe a hung jury, you know what I mean, something like that. Maybe he can do that.
Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out.
Hey, y'all, hit the subscribe button. Stop playing, bro. Why y'all playing? Hit the subscribe button. Hit the like button, push that. Shout out to everybody hit the like button, because we just jumped another 1,000. You see what I'm saying? You know, another 1,000 views unprocessed. Y'all gonna see them later. But hit the like button, bro.
Who's in contact?
We trying to get to 100,000 subscribers. This 60-something thousand subscribers. No, we gotta get. Hey, there are people with millions of subscribers out here, bro. We could do it. Come on.
Who's in contact with Govan, according to Mr. Smith? Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning, and of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time, and put an officer on the stand, the lieutenant, to talk about getting access to the time, you know, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician, it's a computer, I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times.
Hey, he trying, man. Like, nah, he trying, but nah, this ain't enough, bruh. This ain't enough, bruh.
Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose.
Hey, yo, man, he got one of them Tay-Rock rounds, bro. He just, like, all right, bruh.
Minutes, thereabouts, to pick up Cornelius Smith. They got to leave, then turn around and go to Bradley, and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21.
Is it like against conduct of a lawyer to be more dynamic? Is it like, you know what I mean? Like, you can't handle it. Like, you know what I'm saying? Like, is that against the rules? Somebody said this is his courtroom debut. Man, this dude is freestyling. He about to get up there and be like, like this dude is freestyling, bruh.
Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you got to park, you're presumably dropping a child off, there's going to be some kind of an exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time, is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had the security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. He didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. I asked Detective Browning if he was aware of any video from there. No.
Hey, y'all go to my Twitter, you know what I'm saying? Share, if you got Twitter, share this video on Twitter and I'm gonna retweet you on Twitter.
If Cornelius Smith, right, is this person.
You gotta at me though. Like somebody just added me, I retweeted them. You gotta at me though. But shout out to the Art of Dialogue, they following me and everything. Shout out to them.
Is telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22. When he was meeting with law enforcement. And I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right? For you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. Some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them.
Hey, AG2 said, I will be nodding off at that jury stand. Bruh, can you imagine like being like, bro, you want to go home? They paying you like $2 a day, some weak pizza. You want to like go back to the house watching Netflix. You heard like the Vince McMahon like movie on Netflix. Like, you know what I'm saying? You want to go back to the house and chill, bruh. And this dude just keep talking on and on and on. And then you watching the prosecution put on a masterful case. You know what I'm saying? Like a masterful argument. And then you, maybe a little boring, but a little masterful. And then you got this guy that had nothing to say. Now you got all this to say in the closing argument. You're going to be like, man, come on, bro.
And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy?
Yes.
And not walk away and go, I just don't know if I did the right thing.
Yes.
Knowing that there was information out there that could have been presented to you and wasn't.
You know why I wasn't presented to? Because you ain't present nothing. Bro, I'm looking at so the Law and Crime Network, right? They did a poll, right? And it said, what would be the jury's verdict in Tennessee versus Justin Johnson? Bro, it's like, it says guilty 90%, not guilty 5%, hung jury 5%.
That would have been favorable to Mr. Johnson. That I couldn't get. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no.
Hey, yo, the Law and Crime Network, wow, it looks. So they... Yo, they wildin'. All right, so it says, they got something up here. It says, P. Diddy and Justin Bieber, a closer look. Yo, they wildin' on this shadow, bruh.
When you examine your conscience back there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. Okay. You've heard the statement, right? We ain't got nothing to prove. You may say that to somebody, like, I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt, right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, the last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case.
But didn't it sound like the prosecution, like somebody that was working with the prosecutor, like already then put out like the slideshow? So wait, so they get to talk again?
My honor to present this case before you all, and thank you so much.
It's been your honor, bro. You didn't do nothing. Get out of here. You tried to freestyle around, bro. Like, we not doing that, bro.
What do we know about Hernandez Govan?
All right, so this is the prosecutor.
He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here and testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come to court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe it? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. Somebody made a mistake on one slide about the time, so it was corrected. So we can't believe the video.
Hey, just me. I just retweeted you. You know what I'm saying? Y'all share the video on Twitter and I'll retweet you. Shout out to everybody, man.
You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kissing Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that?
Y'all, if y'all can, hit the Cash App too, man. Like, it's the money sign Piper Boy Williams. I appreciate it, man.
Well, there's a
Let me know when y'all do.
Valero video which shows something strange. Shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration. Where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a Crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's those two in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, as soon as you see the video crossed out of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a codependent who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting, of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the
Yo, this dude's so southern. He gonna say a twinkle like. Who be talking like that, bro? Like, yo, the twinkle lady. Oh, this dude, bro.
homicide, we have a text. From who? Trayvon Ingram. To who? Justin Johnson. Sending him what? A picture of a white Mercedes. What do we have next? Another text. Justin Johnson. Trayvon Ingram. Dropping his location. Bradley. Kiston said they met on Bradley. Then they drove to the Lara. And they switched cars. That's corroboration. So do you have to be willing to trust Kissinger with the keys to your car? Of course not. You think I trust Kissinger with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valero. It's documented in his phone with literal pictures and locations. This is plain as day. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissinger's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I miss a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar says. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see the video, of course. What he testifies to. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway or there on the front. Well, we know the white Expedition is also Justin's car. We've seen it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition? Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving a white Mercedes. He hands me the keys to the Expedition. He gives Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see it.
You know, that's kind of weird, like looking at court. Even though you literally just watched everything that went down, like the prosecutor put all of this evidence up, they still have to like go all the way back. You see what I'm saying? And like work their way through all the evidence that they provided to remind like the jury, because sometimes the jury can forget some things. Even when it's like in your face, all this evidence. You know what I'm saying? But shout out to everybody. I just look, we got 18.8 thousand like views on this video. Shout out to y'all. Hit the like button, subscribe.
We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in a Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax gone, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments, when this trial was just over again for the 5th time, was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's Big Joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's time? I mean, delete stuff all day long. He did. Whole day. November 17th. Deleted all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joe. With Big Joe. Cornelius tells you. And there you see it in black and white. It's not 1981. No, that's true. Call on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joe right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Do you have enough time to do it? Yeah, he had enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis Talk. All the times. All the times. Before the murder, we see him at Crosstown. In the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs. Bass Pro hat. Everything. Before the murder. The Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder?
All right, can you imagine being the court reporter and these dudes just won't stop talking? I'd be like, can you hurry up? Like, can you imagine that? Like the carpal tunnel like she must have. Imagine like after this case. Like, bruh. Ain't no way, bruh.
Again, caught on video. White Mercedes, back end damage. The exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you call it? Who you texted? Big Joe. Called before, called during, and then called after. That includes video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He's literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we have? Another method phrase. Get on down. Get on down. Cross town the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, on manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down.
But interesting thing is Govan decided not to testify. So we've been hearing that, you know, even the defense thought Govan was going to testify, but he decided not to.
Now, the crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt? Well, yeah. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming, and he was out of town and leaving. Really. Really. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces and stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on conspiracy to commit murder. Because he wasn't there for at least like one of these meetings with Big Jook or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder. He's not at this meeting with, you know, Big Jook and Govan and 20 others. So let's cut a little break on that. That's what I heard. Let's cut a little break on that. Now, there's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this, like, understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break and leave, no. He's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one lyric. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come on. What he saw in neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long is the video take? 30 seconds? You're too real. Dies on the floor in a neighborhood cookie store in Orange now. It's real. You're too real. Your family misses you. Erica and Mia and the kids. You're too real. This is real. This is too real. And when the killer
Your verdict will be, we the jury find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Yeah, she. Hey, I had to fast forward. My bad, bro. Like, this dude.
Commit first degree murder as charged in
So they found him guilty.
Right. Cornelius Smith and Justin Johnson.
guilty of conspiracy to commit first degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury found the defendant guilty of conspiracy to commit first degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit conspiracy to commit first degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury find the defendant guilty of facilitation to wit conspiracy to commit first degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offense as charged and included in the... I guess we need her. So for the record...
All right, we're about to say what this is about. All right, so we got to get to this verdict, bruh. We heard the closing arguments from the defense. The prosecutor is so boring, I can't sit through that.
Relating to section 1, page 5. Agreement is in quotation marks.
We back in session.
So I don't think there is a legal definition to the term agreement.
Don't either. I remember struck it as answering a question before with a jury saying that when a word doesn't have a legal definition, as applied here, to go with the common, usage. But beyond that, I don't think anybody can comment more than that.
Right. Or I can say, no, there is no legal definition, which leaves them with their common knowledge about the word.
I would just suggest to say common, like you said, there is no legal definition.
Bro, I thought y'all...
And when there's not
Bro,
common meaning of the word.
y'all tricked me, bro. What that verdict at? What a verdict at, bro? Like, I don't want to be sitting here listening to this judge talk and the boring prosecutor talk. Where is this verdict at, bro?
But everybody.
Mr. Evans.
I think based on kind of thinking about it for a minute, I think that you can only, I would suggest just saying there's no legal definition. I don't have a problem with saying.
If that's what Mr. Evans is asking for, that's fine.
With saying something to the term of, everyday usage, or what I was referring to is consider all the evidence in light of your own observations and experiences in life. That's not really specific to defining a term, so that may not be helpful to them. But I think either way it's phrased, it would be fine.
And I'm just going to respond to this in writing. We don't even have to bring them out. Okay?
Y'all is terrible. Somebody in the comments, Don Vaughn, saying Justin better ask Diddy for some baby oil. What is you talking about, bro? Like, oh man, come on, you gotta chill, bro. You gotta chill. Hey, Cassandra says she is baffled at the court hearing. So the judge had to like instruct them on what they're gonna be making their decisions on and everything. I don't. Sometimes you get somebody. You know how like when you in school, you know what I'm saying? You went to college or whatever. You in school and you trying to go home. You know what I mean? Or you at work. Let's just say they have a meeting at work and you trying to go home, and it's that one person that keep talking. You like, man, come on, like, why you keep talking? You know what I mean? It's that one person that will not stop talking, asking questions. They probably dealing with something like that in deliberation. You know, it's like they done laid out all the facts, but somebody just want to be seen and speak, and you know what I mean? Just all, you know what I mean? They just like, come on, bro. It's like, it's right in your face, like everything that, but you know, like the defense attorney did say, we didn't see him in the Mercedes. What you mean we ain't see him in the Mercedes? We didn't see him run to the Mercedes. What you talking about? But yeah, but the defense did specify that the cops couldn't really say they knew what the time was during. Like, come, you know, it's gonna be that one person that they got dressed up. They know this the last day, and they just want to talk. They might pick like an old person and stuff. Shout out to the old people. They might pick an old person that might be like, nah, baby. He a young boy, and we really gotta think about this a million times before we come to a decision. One of them old type people, they ain't got nothing to do in life and happy they around people and they want to talk to them. I don't want to talk to you, Clara. I want to go home. Before we get started, how's everybody today? You know, they might have one of them. Somebody said, does Tennessee have the unalive penalty? If so, would they be eligible for it? Yes, they have it. They have the electric, you know what I mean? And then they have the you know what I mean? The needle and all that. They got both of them here, you know, but I think they, I'm not sure if you can use the chair anymore, you know what I'm saying? But they allowed one dude to use it because I think they just wanted to see like if it worked because they didn't use it for so long. But they let one dude use it. He used it. You know what I'm saying? So I don't know, like what they use now. Hold on. But yeah, we got it. It said current status, Tennessee has carried out 13 of them things since the reinstatement of that one in 2000 under Governor Don. So basically they run it down like all of them. But yeah, since they reinstated it, yeah, they had 13 of them things. You know what I'm saying? So yeah, they can, yep, they do that. They will, I mean, they're not as active as Texas, but yeah, I mean, you can come down here, you playing around, you know what I'm saying? You might get it. Oh, y'all about to be mad. It said jury is now deliberating in Tennessee versus. Come on, bro. Hey, y'all want to be lawyers? Nah. This is boring, bro. Being a lawyer? Cause you think this is not a job you could just like do your job and go home and chill. This is a job you gotta like, you go home.
There is not a legal definition for the term agreement.
You're in, you know what I mean? Like you gotta look up all these legal definitions. You gotta get a slideshow ready. You gotta do, man, I'm trying to play Xbox. By the time you done with like, you know what I mean? Going over what everything happened in the trial and, you know what I'm saying? And then you prepare everything for the next day and you got like 3 days, 4 days of this. Nah, bro. You ain't never gonna watch Netflix. Like, doing this? You want to go to the club, you want to chill, but you know, Monday morning, you know, a big situation, like, man, look.
Okay. I think the less the better here.
I agree.
Okay. All right. Thank
No,
you.
they still in deliberation.
Your duty to acquit him. Your verdict will be.
Cassandra tricked us, bro.
Too real. Last last moments of his life, last seconds of his life. How long was the videotape? 30 seconds? You're too real. Dies on the floor of a neighborhood cookie store in Orange now.
Hey, yo, I'm low-key thinking about going to get some of them cookies, bro. Cause like, if you're willing to like risk everything for these cookies, I mean, these cookies gotta be good, bruh. What y'all think? Like, should I go get some of them cookies, or should I just like have them like delivered or something? Like, I'm just asking. These cookies gotta be good, bruh. I'm about to go get some of these cookies, bro. You know what I'm saying? Like, I'm gonna go live one day, and I'm gonna let y'all know if these cookies is what it is. You know what I mean? Like, I'm gonna have to. You said too soon. No, not about the Dolph. Like, you know what I mean? Like, shout out to Dolph, all that. I'm not like. Trust me, I don't. You know what I mean? I don't want y'all to misconstrue none of this. I'm on Dolph's side, but the cookies. They talked about these cookies a lot. And I kind of just want to know, is the cookies good? Let me know that. Hey, cookie place. I got a P.O. box and all that. You know what I'm saying? Well, I don't got one. I'm capping. I can get one, and y'all can like deliver me some of them cookies, because I need to know what this is. You said, and you got to get the butter cookies too. I'm going, bro. I got like 2 weeks off work. I'm going to get some cookies, bro. Like, I'm not going to tell y'all when I'm going to do it. I'm going to have to rent like a Kia Rio or something like that, because I can't be like up there, like me covering this trial. You know, I can't be up there at all. Yeah, I mean, I'm on Dolph's side. But I did say some unfavorable things about Juke. So I'm trying to be careful here. You know what I mean? So, but I want them cookies. Let me know if I should get them cookies in the chat. The chat, hey, chat, keep it real. Have y'all been thinking about them cookies? We've been sitting here for like 3 hours talking, everybody, we kicking it. We not about to act like we have not been thinking about them cookies. Philly Phil said, I want a cookie. I want one of them cookies too. I'm sending somebody to get, hey, if you're in Memphis, get the cookies. Meet me. Hey, I want a dozen cookies. I'll buy 2 dozen of them, right? You get to keep a dozen, I get a dozen of them cookies. I can't go in that store. Because of this whole thing we just watched, I'm not going nowhere near that store. But I want the cookies. So somebody go on Twitter, hit me up if you over there in Memphis. We're going to have to figure out an arrangement, because I got to get them cookies, bro. I got to see. I got to see. I gotta know.
Too real. Your family misses you. Erica and Nia and the kids. You too real.
This chat is crazy. They said they sell them at the grocery store. Like, bruh, they not the same. Bruh, if they was the same cookies, none of this would have happened. They got, bruh, I want them cookies. I want to know why, like, why people like them.
This is too real.
Hey, the person in the chat saying, I like my cookies soft, bruh. Don't let Diddy hear that. Don't let Diddy hear you just said that.
And when the killer wanted to do
Hey, can you- I know we talk about entertainment now, but y'all gotta chill. Hey, I like my cookie soft. Give me them soft. Y'all is wild, bruh. Nah, yeah, I see. I'm paying attention to y'all. Y'all tripping. My chat tripping, y'all. Like, no. Imagine, like, y'all. All right, y'all go on Twitter and post that. Just post that on Twitter. I like my cookies soft. Watch one of y'all go viral. You gonna see a whole bunch of Dame Dash under there with the gifts like, pause.
just caught on video all the times. We even watch him get on down. It's time for us to be real.
All right, so we're gonna have to come back with the verdict hit. We got like 20-some thousand views in here. You know what I'm saying? Y'all gonna see it in a minute. You know what I'm saying? We got 20-some thousand views. We've been on here for 3 hours. When the verdict hits, we back. I'm gonna let y'all go get some cookies. Cause I'm really about to investigate this. I'm a DoorDash, bruh. I'm a travel to Memphis, right? I don't know what day. I'm traveling when the cops outside. I'm traveling to Memphis, and then I'm a like have DoorDash meet me with some fresh cookies of the sugar cookies. I'm gonna let them know I want the cookies soft. Like, pause. Don't let them put no hard cookies. Pause. Don't DoorDash. Don't let them give you no hard cookies. Somebody said soft instead of crunchy was wild, bro. Some oil would have been softened them up. I'm getting out of here, bro. Y'all is crazy. I'm out. We coming back for the verdict. Hey, I'm gonna need somebody on Twitter. Follow me on Twitter. Let me know on Twitter when they got the verdict. All right, I'm out. Peace. Wait, hold on. Let me see something real quick. Let me get this. Let me change something real quick before I'm out. All right, Keenan. All right, everybody. Cassandra tricked me. All right, everybody. Cassandra, you did. Cassandra on timeout. How you gonna trick me like that, man? You said what day I'm gonna be? Hey, as soon as the verdict come, we going live. I ain't got no more notifications, but we going live anyway. We gonna have like 3 people in here, and we gonna be in here for like an hour. You know what I'm saying? All right, y'all, I'm out.